Good day to you, and welcome to another Paddocks Club video tutorial. Today we're going to talk about the recent amendment of the regulations under the Sectional Titles Act. They take effect in a month's time, and the details of where you can find them are on the screen now. Let's have a quick look at what they're all about. Well, it's mostly registration-related issues, but there are 4 changes to the prescribed management rules, and this will be our focus today. The program for this tutorial is the further proviso added to PMR 7, Subrule G added to PMR 13, the deletion of Subrule 31.4a, the insertion of a new 31.4b. So that's as far as we'll go today. Let's have a look at the purposes of the changes to PMR 7 and 13. These are to ensure that an owner in arrears with his or her levies or in persistent breach of the conduct rules despite written demand cannot be nominated or elected as a trustee of the body corporate. And secondly, if a sitting trustee is in levy arrears for more than 60 days and gets 7 days notice, he's automatically disqualified. Let's have a look at the detail of that. You'll see at the bottom the new proviso to PMR 7. It reads, provided further that no nomination or appointment as trustee of a person in breach of Rule 64.1 or 64.2 may be made or accepted. That has the effect that I explained a moment ago. You then look at the insertion of PMR 13G, the other side of this puzzle, and this is basically an additional ground for disqualification of a sitting trustee if the trustee is in arrears for more than 60 days with any levies and contributions payable by him in respect of his unit or exclusive use area, and if he fails to bring such arrears up to date within 7 days of being notified in writing to do so. At that stage, at the expiry of the 7 days, he or she is disqualified from being a trustee and automatically taken off the list of trustees. That could have its own set of problems, but that's the position, or it will be the position in a month's time. Then let's look at the purpose of changes to PMR 31. First is a deletion of PMR 31.4a, and this is a bit strange. There doesn't seem to be any actual purpose to this deletion, and when Paddocks Club member Steve Webb tried to get the Department of Rural Development and Land Reform to tell him why this had happened, he spoke to Antoinette Reynolds, who said, well, this was what the Regulations Board wanted. It was their idea. When he contacted Barbara Shingler of the Sectional Title Regulations Board, she seems to accept that this is a mistake and that the new Regulations Board to be appointed under the new legislation will have to fix this mistake. It's a pity because there's been a bit of a history with mistakes. You'll see that the insertion of PMR 31.4b is what used to be PMR 31.4. It's a correction of a previous Sectional Title Regulations Board error in removing this clause, so it's now been replaced with the same wording as before. So let's go back to the detail of those. This is the clause 4a that has been deleted by mistake, it seems. It's the one that deals with fiscal drag, allowing trustees at the end of a financial year where there have been increased expenses to increase levies by up to 10% to take account of the body corporate's increased liabilities. A useful provision and which seems to have been removed for no reason. Hopefully we'll see it back in again. Then there's the insertion of PMR 31.4b. This is the straightforward provision for special levies, saying if they're unbudgeted and necessary, the trustees can raise the levy, and they then can make a decision, as they would after an AGM, to say that these are payable in one sum or in such installments as they think fit. Thank you very much for watching this video tutorial. If you have any questions in regard to these changes to the PMRs, let's deal with them in the in the Paddocks Club discussion forum. And remember, they come into effect on the 14th of March 2013.